and the restrictions regarding lockout, strike and lockout, and the penalties for strike and in respect of strike and lockout. It's a part of our Unit 2 of Labour Law 1. And in the previous clip, we have been discussing with reference to the powers and procedure of various authorities, and we have also dealt with reference to the mechanism or authorities provided under the Industrial Disputes Act for the adjudication of an industrial dispute existing or apprehended. Okay, right. Section 3.2, 3, 4, 5, 6, 7, 7A, 7B, 9C and 10A dealing with such authorities. 3 Works Committee, 4 Conciliation Officer, 5 in a Board of Conciliation, 6 Court of Inquiry, 7 Labour Court, 8 Industrial Tribunal, 7A Industrial Tribunal, 7B National Tribunal, and 9C Grievance Redressal Agency or Grievance Redressal Mechanism, and 10A reference of the disputes by the parties to the arbitration, which they have by their mutual agreement constituted the arbitrators, appointed arbitrators with their consent. Okay, then we proceeded to section 10 regarding the power of reference of the dispute, power of the appropriate government in making the reference of the disputes to any of these authorities under section 10, and we have dealt with what all the various provisions under section 10. Section 10, clause 1, 10.1a, 10.2, 10.2a, 10.3, 10.4, 10.5, 10.6, 10.7. I mean 10.6 only total. So there are in all 8 provisions. The provision number 1 that you refer by making an order in good faith after framing an opinion that dispute whether it is brought to your notice by the parties, whether by any of the party or both the parties, or on your own. If at all you have got to know that there is a dispute either existing or apprehended, these are the 2 of the forms, any of the form may exist, then you may make an opinion in good faith, pass an order in writing for reference thereof. To whom? To the conciliation officer after appointing the conciliation officer, to the board of conciliation after appointing the conciliation, where the dispute is existing or apprehended. Where the dispute is existing or apprehended or in connection with the matter relevant or connected to the dispute, then you may refer to you may constitute a court of inquiry for detailed inquiry in reference to that particular dispute. Or if the dispute is with dispute means dispute existing or apprehended, if it is with the reference to second schedule of Industrial Disputes Act, then the dispute could be referred to Labour Court. As I said yesterday, even the dispute may be with reference to the matter contained in 3rd schedule, still it could be referred to the Industrial normally it will be referred to the Industrial Tribunal, but still it could be referred to the Labour Court if the number of the persons or workmen affected by the dispute is less than 100. And then we have proceeded, when you can make the reference to the National Tribunal, you means not appropriate government there. The appropriate government will always be central government if it is referred to the National Tribunal. But to this Industrial Tribunal, Labour Court or any, the appropriate government could either be central government or state government, depends upon where the dispute exists, in which particular establishment, and that establishment is operated or administered under the statute of the state or central legislature accordingly, or whether it is controlled by the state or central legislature accordingly. So that will be the case. But whereas if it is to be referred to the National Tribunal under section 10.1a, appropriate government is always central government. Central government, after framing an opinion in good faith, pass an order in writing for the reference of such a dispute, where it involves the questions of national importance, where it involves where it affects interest of 2 or more states, where it is a fit case to be decided by the adjudicated by the National Tribunal. Therefore, the appropriate government, being a central government, could refer the dispute to National Tribunal. This is what section 10.1, 10.1a, 10.2 and 2a, dealing with whether the parties are applying severally or jointly accordingly. And if they are applying severally, then you may make you may contain that, whether jointly or severally, you may contain that in the order of reference. Then where the dispute is referred, the time stipulation is to be mentioned. Okay, time stipulation means time limit within which you are expected to complete the proceedings and submit the report to the appropriate government. then it proceeds. 3, 4, 5, 6. 3, 4, 5, 6 what? In case if the time limit is stipulated not enough, then adjudicating officer or presiding officer may apply to the government concerned to extend the time thereof. Then 3. During the continuation, during the reference, during the pendency of the proceedings, commencing or continuing with the strike or lockout prohibited. And it is made punishable, therefore. Then you have got 4 dealing with the, 4 is this. During the pendency, it is prohibited. Then you have got 10.5 dealing with where, 1 minute. Let me state clearly under section. Okay. 10 clause 4 says, where in the order referring to the referring an industrial dispute to a labour court, tribunal or national tribunal under section, if the appropriate government has specified the points of a dispute for adjudication, the labour court or the tribunal or national tribunal, as the case may be, shall confine the adjudication to those points. Okay. That is under section 10 clause 4, where the appropriate government, while making the reference of the dispute to the labour court or tribunal or national tribunal, then the labour court or national tribunal or industrial tribunal shall, in the course of their adjudication of the dispute, they will confine their adjudication to the points thus specified in the order. And 10 clause 5 says, subsequent to the reference of the disputes to any of these authorities, if the appropriate government finds that some points have been left out which should have essentially been included within the order of reference, then appropriate government may subsequently pass an order for inclusion of those points thereof. When it is included, the labour court or wherever it is pending, they should continue the adjudicatory proceeding in respect of these points too. Section 10 clause 6 dealing with the section 10 clause 5 again, that if any other establishment is affected by the industrial dispute, if it is brought to the notice of the appropriate government subsequently, then it may include those other establishments as well. And section 10 clause 6 dealing with suppose if the case is pending before the labour court, if the central government finds that is a case fit to be decided by the national tribunal, then it can transfer the case to national tribunal. When it is moved to national tribunal for adjudication, then the labour court proceedings will be stayed. It will be suspended, right? This is what section 10 and various provisions pertaining to the power of the appropriate government in making the reference of the disputes. But such a reference of the dispute, the power exercised by the appropriate government under section 10 could be challenged on several counts. What all those grounds of challenge on which party or parties could challenge the reference, the power of the government, power of the appropriate government in making the reference of dispute could be challenged under section 10 only. Whatever the power exercised by the appropriate government could be challenged by the appropriate government. Whatever the power of the reference of the disputes to any of the authorities made by the appropriate government could be challenged. And such grounds of challenge could be, I proceed to strike and lockout, but I am just having a recap to those for your kind consideration. The grounds on which the power exercised by the appropriate government under section could be challenged are when you are not appropriate government, two, when it is not industry, where the dispute is existing in the establishment, it is not industry. 3, it is not a living industry. Okay, it is not a living industry. Okay, add not, etc. Then 4, it is the dispute is not connected with or relevant to any industrial dispute. Okay, when the dispute is not at all relevant or connected with any of the matter connected with the industrial dispute, then it can be challenged. 5, when it is res judicata, like this particular dispute is already referred and disposed of, why did you again? Then 6, you have not made a bona fide opinion in writing. The government, upon coming to know that there is a dispute existing or apparent, then it should pass an order after framing an opinion. If the appropriate government has not framed the opinion, then it is not a valid reference. Then 7, if it has not passed an order in writing. And then 8, what is that? if it is not at all a industrial dispute, correct? It is not industry and it is not connected or relevant to the industrial dispute. It is not at all industrial disputes, etc. Okay. Then one more is there, when the dispute has been referred by you, but when that dispute, whatever the matter connected with the or relevant to the dispute, when the dispute is referred by the appropriate government to the any of the authorities, but unfortunately that should not have been referred. Why? The matter is covered by the settlement. When the matter is covered under a settlement entered into between the parties, reference to the disputes during the period of operation of settlement, normally it will be 6 months, then reference is bad. You understand? Okay. This is what? These are the grounds on which the power of the appropriate government, power of reference to be exercisable by the appropriate government could be challenged. I said 1, when you are not appropriate government. 2, when it is not industrial dispute within the meaning of section 2K of the Industrial Disputes Act. 3, when you are not an industry. 4, when the dispute is not relevant or connected with the industrial dispute. 5, when you have not made an order in writing. 6, when you have not framed the order in good faith. 7, when you have not framed any opinion as to whether the dispute is existing or apprehended, negligent. 8, when it is res judicata, a repetition. It is already referred and discharged of. Why do you again? Yes. Then you can say that. What is that? I think these many grounds on which you can challenge the power of appropriate government under section 10. Let us now proceed. Then we have discussed about the procedure to be adopted by the authority. When the dispute is referred to it, what procedure authorities are to exercise? Section 11 we have seen. That is power to make an entry, commence the proceedings, power to make an entry where the dispute is existing, and exercise the civil court procedure, because you are a civil court within the meaning of a CPC as such. All those administration of examination of persons by administering both some issuing of summons for production of document, appointment of accessors, experts to be assisted by, etc., and to determine the cost by whom to whom and what amount is to be paid, etc. They all can exercise those procedures under section 11. And 12 to 15 says that commence, conduct and complete the proceedings. While commencing the proceedings, you should observe principles of natural justice as well. Okay, and finally submit the report to the government. Government upon receipt of the same shall publish the same within 1 month from the date of receipt. When upon publication it becomes an award. And then also we proceeded about section 16, 17, 18, that is provisions pertaining to award, section 2 clause B. Okay. Then provisions relating to settlement, section 2 clause P. We have discussed. Now let us proceed to that strike and lockout. We have defined in the previous clip regarding the meaning of strike and meaning of lockout. Strike mean, and there only we can bring about the various features of strike. What do you mean by strike? Strike means cessation of work by a body of workmen employed in an industry. Cessation of work by a body of persons employed in the industry, acting in combination and under a concerted refusal and under a common understanding of any number of the persons who are or have been so employed. Yeah, what is that? Finally you are coming to the connected word. I will come back to it. Section 2Q defines strike means collective stoppage of work, cessation of the work by a body of persons employed in the industry, acting in combination or under a concerted refusal or under a common understanding of any number of the persons who are or have been so employed to continue to work or to accept the employment. Their concerted refusal, collective refusal must be to continue to do the work or to accept the employment. That is what strike. And from out of this definition under section 2Q of Industrial Disputes Act, okay, it is said from out the definition of strike under section 2Q of the Industrial Disputes Act 1947, we can make out what are the features, the elements of a valid strike. I will put it like elements of a valid strike. One, there must be cessation of work. There must be cessation. Cessation, cessation. Cessation means stoppage. There must be cessation of the work. Two, the cessation of work must be by a body of the persons employed in the industry. The collective stoppage of the work must be by a body of persons employed in the industry. And the persons stopping, the persons striking, they must have acted, they must be acting in combination. And then the person taking part in the strike must be working in the establishment which can be called as industry. The person taking part in the strike, the person taking part in the cessation of the work, those body of the persons employed in industry, they must be working in an establishment which can be called industry within the meaning of section 2J of Industrial Disputes Act. Then there must be a combined or collective refusal, and refusal must be under a common understanding of any number of the workmen employed in the industry, either to continue to do the work or to accept the employment. And then finally, what is the object? You started. There must be cessation of the work. Cessation must be by a body of the persons employed in the industry. Then the person striking must have acted under a combination, and the person taking part in the strike must be working in an establishment which can be called as industry within the meaning of 2J. Then there must be concerted refusal, combined refusal, collective refusal. Then refusal must be under a common understanding of any number of the workmen who are or have been so employed, to continue to work or to accept the employment. And finally, the object of the strike must be in furtherance of. What is the object of the strike? You are now going on strike. What is the main object of the strike? The object of the strike must be in connection with the employment, non-employment, terms of employment, conditions of employment. The object of the strike must be related to, that's what. If there is no drift, if there is no difference, if there is no dispute, what is a dispute? Not personal, industrial dispute. So strike must be related to industrial dispute. What is that industrial dispute? Dispute or difference between employer, workman, employer, employee, workman, connected with employment, non-employment, terms of employment, conditions of labor of any person, or conditions of employment. Correct? So therefore, object of the strike must be related to employment, non-employment, terms of employment, or with the conditions of labor of any person, any workman as such. So these are the features that we can bring about from the definition of a strike. Then what do you mean by lockout? Temporary suspension of the business or temporary closure of the place of employment as a means of exerting pressure on the person striking or person contemplating to strike, as a means of exerting pressure on them. What for? With the sole objective of resuming, making them to resume or making them to come back to the work as such. So that's what. Temporary suspension of the business or temporary closure of the place of employment as a means of exerting pressure with a view to compel them to resume the work. That is what. And you can see now what are the features of lockout. What are the features of lockout? If at all we deal with those features of lockout, as such, features of lockout could be the following. Namely, lockout must be in consequence of industrial dispute, correct? And there is a temporary closure of the place of employment or temporary suspension of the business. Okay, it need not be entire place. Temporary suspension of the business or temporary closure of the establishment, and it must be as relating to the industrial dispute. And the object of the lockout is to coerce the employees or workmen to accept the work and resume the work. That's it. So you can see that. Now, can they resort to strike? Can they resort to lockout? See, if you are in the government establishments, then there cannot be this kind of a strike or this kind of a lockout. I mean, sorry, you can, but you are in the public utility service. Therefore, you have to observe the procedure under section 22, and even you are governed by the provisions of section 23. What I mean to say that you cannot form a trade union. You being in the government service, you being in the sovereign service, you cannot be what is that called? You cannot be establishing a trade union as such. Your association could be, but it is not to be called as a trade union. But this strike is very much available. You can, but since you are in the public utility service, of course, if it is essential service means still it is subjected to so many restrictions. You cannot take the people to ransom. You cannot take the public to ransom as such. But still, the right to strike is not an absolute right. We have already discussed in the very beginning the absolute right to strike or lockout shall go. Why? Because it is inhuman. It is wicked. It is wasteful of capital and labor, and it is antisocial because it disrupts social solidarity. Okay, peace and social solidarity. But still, it is a right given. We have seen the definition. We have seen the features. And if you go to this strike, there are even types of strike. What are the types of strike? There may be general strike, there may be stay-in strike, there will be go-slow strike, there will be sympathetic strike, there will be pearl strike, there will be tool-down strike, there will be, what is that called, hunger strike. So many. Strike could be of several, types. Sympathetic strike means you are coming to the work and stopping the work. It may be pearl-like, stopping, continuing, stopping, commencing, like. Why? In order to extend your sympathy towards a fellow employee against whom unilateral decision taken by the employer. That is possible. Hey, there will be a question like, there will be solar eclipse, and these workmen requested the employer, to declare it as a holiday. Buckingham Carnatic Company Limited was their workmen. But employer refused to grant it as a holiday, and these people one by one, the employees working there, one by one they started going off from the work, and they started at 1 o'clock, and finally everybody in a mood, strike ended at finally all people went. They asked for a casual leave, they asked for a leave in the afternoon. But employer did not sanction it. As a result, they struck the work, and finally everybody moved out of the work as such, and employer considered that November 1, 1948, employer considered that it is an illegal strike, and workers participated, employees participated in the illegal strike, would not be entitled to paid wages for that half day. 1, 2, they will be inviting some penal provisions, disciplinary provisions. Okay, and employer cut the wages for that part of the day. That is what the penalty has imposed, and workers union challenged before the labor court, and labor court held. Yeah, they have given the notice. That is lightning strike. We can say that. They have given the notice but did not observe the procedure. The appellate tribunal, of course, labor court passed the order in favor of the employees, the workmen, and it was challenged again by the employer in the appellate court. Appellate court again upheld the order of the labor court, and finally it went to the Supreme Court. Supreme Court examined that what is the procedure laid down under the statute is, this is 1947, is section 22. What section 22 says? In order to commence a strike, in order to declare a strike, there are two types. One, strike by the employees in the public utility service, and strike by the employees in the non-public utility service. Strike by the employees in the public utility service can be possible. How? By following section 22. What section 22 says? Give 6 weeks notice in writing. Okay, and there will be no strike during the first 2 weeks. And the employees are expected to, the trade union or the employees who are going to strike, they must, who are in the PUS, Public Utility Service, they must comply with the procedure for striking under section 22. What is that? They must give 6 weeks of notice in advance indicating the reasons for striking to the employer. And during the first 2 weeks there will be no strike. Therefore, strike can take place on any day during the last 4 weeks. Okay. And if the date is specified in the notice, then strike cannot commence on the date specified but the following day. If the date is specified out of these, any day of these 4 weeks, if the date is also mentioned on which you are going to commence the strike, then you cannot commence the strike during the, on the day. You have to commence the strike following day because you have specified the date. You have nominated the date on which you will commence the strike. Having nominated, having specified or appointed the date on which you will commence the strike, you cannot commence the strike on the day, on the following day. But if at all you have not at all specified any date on which you will commence the strike, then never mind. No need of it. You can commence on any day during the last 4 weeks. And there again a restriction. Suppose if you are resorting to a strike with reference to pressing of your demands in respect to some matter, if that matter is before the conciliation officer pending, then no question of notice and all, no question of strike. No question of strike taking place on any day during the last 4 weeks. No question of notice of strike can be given because the matter in dispute in respect of which it is referred to, the proceedings are on before the conciliation officer. When it is referred to the conciliation officer, when it is pending before the conciliation officer, no question of commencing or continuation with the strike. You cannot. And as a result, not only during the pendency but also 7 days from the date of its conclusion thereof. You understand? That is what the fourth one. So there cannot be any strike taking place during the pendency of any proceedings, conciliation proceedings, pendency. During the pendency of any conciliation proceedings and 7 days from thereon. This is what the procedure. If you are employed in the public utility service, then the trade union or the employees, if you are resorting to strike, then you must comply with the procedure prescribed under section 22, which says strike cannot be taking place without first giving 6 weeks of notice by the union to the employer. And during the first 2 weeks, no question of strike. And during the last 4 weeks, a strike can take place. If the date is specified, then not on the date but on the following date. And again, there is a restriction that no question of strike taking place during the pendency of conciliation proceedings plus 7 days from the date of its termination of the conciliation proceedings. Similar will be the procedure to be adopted. Similar procedure will be followed by the employer, while this is to be followed by for strike by persons in the public utility service. This is the procedure. Trade union or its members, if you want to go on strike, this is the procedure under section 22 if you are employed in the public utility service. If you are employed in the public utility service, correct. If you are carrying on a public utility service establishment, Mr. Employer, for you to go on lockout, for you to resort to lockout, for you to commence lockout, similar will be the procedure. That means give the trade union a notice, give the employees, a trade union or employees a notice regarding the strike. 6 weeks in advance, a notice of lockout, notice of lockout shall be served by the employer to the trade union or the employees. And second one, during the first 2 weeks, no lockout. You must also indicate why you are locking out, Mr. Employer. And during the last 4 weeks, any day you can commence a lockout. If at all you have prescribed the date, any date of these, out of these 4 weeks, then don't commence on the date, but commence on the following day. And again, if there is any conciliation proceedings pending before the labor court, before the conciliation officer, etc., then there is no question of commencement of lockout during the pendency of the conciliation proceedings plus 7 days from the date of termination. Lockout, similar procedure. Employer will have to follow, employer who is running a public utility service, he shall follow the procedure prescribed for lockout under section 22. 6 weeks notice. During the first 2 weeks, no lockout. During the last 4 weeks, lockout can take place. If the date is specified, then lockout cannot begin on the day but following day. And lastly, during the pendency of the conciliation proceeding, 7 days from the termination thereof, there cannot be any lockout. This is what the procedure prescribed under section 22. Then what are the restrictions? There are a procedure is there, Procedure in itself is a restriction. Remember, procedure itself is a restriction. And there are some general prohibitions or general restrictions contained in section 23. What is the general restriction or general procedure, general provision? General restraints, general prohibitions, general restrictions. These are section 22, dealing with the statutory restrictions or statutory procedure for strike or lockout. Section 23 dealing with the general prohibitions or restrictions for strike or lockout. What are they? There can be no strike. Section 22 you have read. Section 23 says there can be no question of strike or lockout during the pendency of conciliation proceedings before the Board of Conciliation plus 2 months thereof. There can be no strike or lockout during the pendency of any proceedings before Board of Conciliation, before Court of Inquiry, before Labour Court, before Industrial Tribunal, before arbitration proceedings. Okay, if the proceedings are pending, if the proceedings in respect of the dispute is pending before Labour Court, Tribunal, Board of Conciliation or arbitration, then no question of strike or lockout during the pendency, plus 2 months from the date of that conclusion of such proceedings. Understand? Under section 23, general restrictions or prohibitions for strike or lockout. What is that? There can be no strike or lockout during the pendency of any conciliation proceedings before the Board of Conciliation, Labour Court, Industrial Tribunal or arbitration plus 2 months from the date of its conclusion. First one. Second one, there can be no strike or lockout in respect of any matter which is covered by award and settlement. That's it. And then finally I will tell you that no notice contemplated under section contemplated under section 10 under section 22 need to be followed. Whatever notice, whatever procedure prescribed under section 22, that need not be followed. If there is already strike, then you can, if there is already strike, then employer you can lock out without following section 22, without the procedure. If there is already lockout, similar, even the employees can resort to strike without comply with the procedure, provided, I said, if there is already lockout, if a strike is commenced in contravention of section 22 procedure, when there is already lockout, the strike is still valid. When the lockout has commenced in contravention of section 22, when there is already strike, lockout is still valid. Normally, strike or lockout in public utility service can only commence by complying with section 22. But when there is already strike, when there is already legal strike, this is what the reiterating word. When there is already legal strike, for locking out, no procedure contemplated under section 22 need to be followed. When there is already lockout, no procedure contemplated under section 22 need to be followed for striking. That's it. And finally, there are certain penalties. What are those penalty? Penalty, there is a prohibition for giving aid, financial aid. There is a prohibition for giving financial aid for illegal strike and illegal lockout. And if at all it is found that any person who knowingly or spends or applies any money for supporting any illegal strike or lockout, then such a person who is supporting by extending financial assistance for illegal strike or illegal lockout, he will be subjected to imprisonment of 6 months or with a fine goes to 1,000 or with both. So if it is found that anybody is providing financial assistance for supporting or encouraging illegal strike or illegal lockout, then such a person providing or extending financial aid shall be liable to 6 months imprisonment or fine of 1,000 rupees or with both. Then penalty for illegal strike and lockout. If ever whoever commences, it may be employees or it may be employer, whoever commences illegal lockout means employer, illegal strike, employees, then if it is illegal, then they will be punishable with imprisonment for a term which may extend to 1 month or a penalty which may be 50 rupees or with both. Okay, I think penalties might have been modified as well. If ever anybody like employees resorting to illegal strike or employer resorting to illegal lockout, that is in contravention of section 22 and 23 of the Industrial Disputes Act, they will be liable to undergo the imprisonment of 1 month or a penalty 50 rupees or both. Then whoever instigates, abatement he call, whoever provokes or incites or instigates or abates, abatement or otherwise supports the parties for striking or locking out, then it is considered to be illegal, and they will be such a person abetting, such a person abetting or instigating or inciting or provoking will be liable to imprisonment of 6 months or fine which may extend to 1,000 rupees or both. Okay, right. These are all the penalties. Even if you commit the breach of an award or settlement, you will still be liable to fine which may extend to 200 rupees. Okay, right. These are all the penalties referring to strike and illegal strike, illegal lockout. 1. Providing financial aid for promoting illegal aid, illegal strike and illegal lockout. Third one is with reference to in case if the strike or lockout may be legal, but if it is commenced or if it is continued in breach of the award or settlement, when the award is in operation, it will be in operation from the date of publication for 1 year, could be extended by the appropriate government by 2 more years, so totally 3 years. Or settlement, it will be in operation from the date of approval of the agreement of settlement for 6 months. When the settlement or when the period of settlement or award is in operation, in breach of it, if at all strike is commenced, lockout is commenced, then the parties commencing the same will be liable for penalty.